Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Thank you, Madam Speaker, and let me begin by acknowledging that we're gathered here on the traditional lands of the Algonquin people, and I am pleased to join this debate on Bill C-289, an act to amend the Criminal Code, Identity and Verification, which was introduced by the member for Simcoe North on June 16, 2022 of this year. And I want to thank and congratulate the member for all of his work. Although this bill proposes only one change, it seeks to address an important and topical issue in Canada, combating the serious crime of money laundering. The bill aims to discourage money laundering through the provision of false identity information to certain financial institutions and business professions. It would amend the criminal code to add an offense of knowingly providing false or misleading information to these regulated entities when they collect and verify the identity of their clients under the rules set out in the Proceeds of Crime, which is Money Laundering and Terrorism Financing Act. Money laundering is a serious challenge faced by all countries. It compromises the integrity of the financial system and represents a threat to global safety and security. By its very nature as unlawful activity, the scale and scope of money laundering is difficult to measure. Nonetheless, a 2020 study entitled Estimating Money Laundering Flows with a Gravity Model-Based Simulation estimated that US $37.8 billion may be laundered annually in Canada, which represents over Canadian $50 billion. As highlighted a moment ago, the bill proposes one change to address the provision of false information to regulated entities. It is important to consider that an entity responsible for verifying identification under the Proceeds of Crime, Money Laundering and Terrorism Financing Act may face significant administrative monetary penalties or criminal prosecution if it fails to carry out its regulatory requirements to identify and verify its clients. Another important consideration is examining this bill is that there are already offenses in the criminal code that address the activity and its target. The offense of uttering a forged document can apply where a person opens a bank account or purchases real estate for the purpose of money laundering and knowingly uses forged identification documents. The offense of fraud can only apply where a person provides false or misleading identification or other information to a real estate agent or other regulated entity, and that entity faces economic loss as a result. And of course, laundering the proceeds of crime itself is a criminal offense. That offense consists of any dealing in proceeds with the intent to conceal or convert those proceeds while knowing or being reckless as to whether all or part of the proceeds were derived from the commission of an offense. An important feature of the offense I mentioned is that they are broad in scope and can apply to a wide range of conduct. We're aware that money launderers continually shift their methods and approaches to evade regulation and law enforcement. The final report of the Commission of Inquiry into Money Laundering in British Columbia, known as the Cullen Commission Report, highlighted the nature of the problem of money laundering in that province in the casino, real estate, and luxury goods sectors. It also considered less well-known but equally serious aspects of the problem, such as trade-based money laundering, and it examined the fast-growing options for money launderers, including the use of cryptocurrencies, private exchanges, and cryptocurrency ATMs. Responses to the challenge of money laundering may be more effective if they are sufficiently flexible to respond to a variety of situations. New offenses are likely to be more effective if they become from numerous ancillary tools in the criminal code that are available to investigators and prosecutors. Relevant examples include the use of wiretaps in appropriate circumstances, or the ability to rely on copies of stolen identity documents in a court proceeding so that the originals can be returned to the rightful owner or destroyed if appropriate. Bill C-289 does not propose any amendments that would enable the use of these tools for the investigation or prosecution of the offense proposed in this bill. This undermines its effectiveness. Money laundering can compromise the integrity of financial institutions, businesses across the economy, and the investment climate. When states fail to take concerted and coordinated action, the risks are clearly significant. Rightly so, the government has made concerted efforts in recent years to address the risk of money laundering and has been active in international forums. I'm aware that it works to advance international anti-money laundering initiatives through the G7, the G20, the Egmont Group of Financial Intelligence Units, an international organization that facilitates cooperation and intelligence sharing between national financial intelligence units, and through the leadership role that it plays in the Financial Action Task Force, of which Canada was a founding member. Not only that, Madam Speaker, Canada's anti-money laundering and anti-terrorist fundraising measures are regularly reviewed by its peers through the FATF. I was pleased to have learned that in October 2021, a follow-up review under this body placed Canada amongst the best performing jurisdictions in the world. Canada's results as the FATF recognize the impact of this government's ongoing commitment to address the problem of money laundering in Canada. The government has continued to step up its efforts. A few important examples of its efforts since 2020 include new regulation that apply to virtual currency service providers, including foreign providers operating in Canada, and new rules that apply to virtual currency transactions, which entered into force in 2020. Furthermore, to assist in strengthening Canada's response to financial crime, the Financial Crime Coordination Centre, or FC3, was established as a 5-year pilot initiative led by Public Safety Canada in 2019. It brings together anti-money laundering professionals from across jurisdictions with the aim of enhancing interagency collaboration and capacity building through a number of means, including training and expertise development, legislative and policy initiatives, and partner support and best practice resources. Another example includes the commitment of approximately $28 million over 4 years and $10 million ongoing to create a multidisciplinary trade, fraud, and trade-based money laundering center of expertise at the Canada Border Services Agency to strengthen our capacity to tackle this borderless crime. Also, the government committed $98.9 million in 2020 to support the Royal Canadian Mounted Police in strengthening its federal policing capacity. This investment included $19.8 million to establish new integrated money laundering investigative teams across Canada. These teams include police officers, lawyers, forensic accountants, and other specialized experts led by the RCMP. And they investigate crimes using capital markets to harm the economic interests of Canada. Most recently, in budget tabled on April 7th of this last year, the government accelerated its earlier commitment to implement a public and searchable beneficial ownership registry, which will now be accessible before the end of 2023. The government also committed to working with provincial and territorial partners to advance a national approach to a beneficial ownership registry of real property. And finally, the government has committed to establish a new Canada Financial Crimes Agency, which was also announced in the most recent budget. This agency will respond quickly to complex and fast-moving cases of financial crime and is intended to become Canada's lead enforcement agency in this area. So, Madam Speaker, I share my colleagues' concern about the serious challenges of money laundering in Canada. However, this bill risks duplicating existing offences in the criminal code. For this reason, I oppose this bill. It risks being a less effective option for law enforcement and prosecutors, therefore weakening the administration of justice. The government has shown and continues to show through its action that it's committed to adopting its strategies and responses to the significant and rapidly evolving crime of money laundering. I look forward to continuing our efforts to respond to this important societal challenge, and I want to thank the member for Simcoe North for bringing this forward. Thank you, Madam Speaker.